Thanks for having me for the symposium. My presentation today is about Australia's new judicial test of worker characterisation, and in particular, two High Court decisions handed down on 9th of February 2022. These decisions potentially changed the judicial landscape of worker characterisation. Although the cases were litigated for issues under the industrial relations law, they would carry significant consequences in various statutory contexts, including tax and superannuation laws. This presentation is structured as follows. I'll first begin with a question of why worker characterisation is important in the revenue law context. This is followed by the old and new tests for characterising a worker and hirer relationship. For several decades, Australian courts have used the multi-factor test, including the control test, the longest-standing common law test for characterising a worker and a hirer relationship. While the multi-factor test raised much uncertainty as to which factors are to be considered relevant and how they vary the weight in different scenarios, in 2022, the High Court pronounced that focus must be given to how the courts have traditionally examined a contractual relationship by reference to the terms of a written contract. This approach is expected to change some established ideas. Thus, after I summarize the lessons from the recent High Court cases, I will conclude the presentation with some notes on what we should look out for. So why is the characterisation important? Australia's federal income tax law uses the term employee, where its meaning is construed as the common law technical meaning. An employer, according to common law, is obliged to withhold tax from any amount paid or payable from salary, wages, commissions, bonuses, or allowances, and pay tax on the benefits provided to its employees or their associates under the fringe benefits tax law. Income tax is not the only revenue law affected by worker characterisation. A hirer characterised as an employer is statutorily obliged to pay payroll tax under the law and regulation of the state in which they are situated. All states except Western Australia include a relevant contract clause that deems all payments made under a relevant contract to be wages and the person in receipt of the deemed wages as an employee. Under the Superannuation Guarantee Administration Act 1992, an employer also makes superannuation contributions for eligible employees to Complying Super Fund or Retirement Savings Account. Under the Superannuation Guarantee Law, any worker hired under contract wholly or principally to provide labour is entitled to employer contributions, which presumably extends the boundary of common law employees for superannuation guarantee purposes. The wide implications of the common law characterisation of workers can be found in the example of Joshua, Kluger and Foodora Australia Pty Ltd, the case decided in 2018. The relevant work provider was the German-founded food delivery service company Foodora. A complaint was brought against Foodora for unfair dismissal of a worker. 3 months before the court handed down the decision to characterise the company as an employer, Foodora went into voluntary liquidation, to shut down the Australian operations. The decision was not only going to penalise the company in respect of unfair dismissal, the Australian Taxation Office and state governments were also waiting for the decision so that they could recover unpaid taxes, superannuation, and related penalties arising from late or overdue payment. There may be two judicial approaches to the characterisation of workers. The first is the purposive approach to the legislative interpretation. This approach was taken by the Supreme Court of Canada and the US Supreme Court. On the other hand, Australian courts have given limited regard to a purposive approach. Its principal approach has been that the judicial meaning is important for interpreting an undefined statutory term unless the statute provides a technical meaning otherwise. At the time that Fedora case was decided, and for several decades preceding the recent High Court cases, the Australian courts applied the multi-factor test to characterize the relationship between worker and hirer. The essence of the multi-factor test is, just as Mason noted, that no one matter is determinate. Let's have a look at various factors considered under the multi-factor test. The multi-factor test evolved from the concept of control used in worker characterization. These days, the common law's interest in employment is largely confined to vicarious liability in tort law. Earlier, the court had asked the question also to discern whether a criminal offence was committed by an employee in the course of employment. So the history of control can be traced to both vicarious liability in common law as well as the criminal law. For characterizing a worker and hirer relationship, the nature and degree of control has been a significant, if not dominant factor. Control was not confined to directing a worker, but the manner in which work was performed was also considered in this context. Referring to control, the High Court once said that importance was not so much in its actual exercise, although clearly that's relevant, as in the right of the employer to exercise it. However, control was long rejected in the Australian courts as a prominent factor in characterizing an employment relationship under tort. Just as Mason said, control was merely one of a number of indicia. That said, some factors used in the multi-factor test in later cases show close connections to a hirer's control over the worker. The factors connected to the right to control in applying the multi-factor test are summarized in the slide. These factors are often found in the contract. First, employees perform work under the direction or supervision of the employer and do not operate independently. They generally follow the steps that will produce a result, whereas the contractors are engaged for the delivery of a specific result or product. Contractors may delegate work to others unless agreed otherwise with the work provider. The second is rectification. Employees are not responsible for fixing any mistakes, generally speaking, whereas contractors are responsible for fixing any defect. Similarly, employees generally bear no risk, no financial risk, whereas contractors are liable for poor work or injury sustained while performing a task. Public liability doesn't cover contractors. Third is work hours and leave entitlement. Employees don't generally have the right to work as much or little as they want, or take leave as often or as long as they want. They generally work standard or set hours on set days, as instructed by employer or covered by a workplace award agreement. On the other hand, contractors can decide when and how often to work in many cases. While the foregoing point to the duties and obligations of the parties, other rights and contractual terms may be considered. For example, fourth, the right to reject or accept work, and fifth, the mode of remuneration. It's important to see them in balance with a central question in mind, that is, whether the relationship is one of employment or contractor. Modern employment entitlements may blur the distinction between employee and contractor. For example, the right to accept or reject work appears to be one of a contractor. It's also an essential right of an employee. Both can choose to work or not to work, although an employee's choice tends to be confined to the whole of the work, while a contractor may have the choice over part of the work. The mode of remuneration is another factor that requires caution. Although the recurrence of payments generally belong to an employment relationship, contractors may also be paid regularly and on a recurrent basis. Flexible working arrangements can inappropriately detract from the characterization of an employment relationship. Over time, the Australian court has developed a conventional view that If equipment supplied is of high value, the worker supplying the equipment is likely to be a contractor. To illustrate, two decisions involving the courier company Vadoo Pty Ltd are relevant. In the first case, Vadoo was brought to court for unpaid superannuation for its employees. But the New South Wales Court of Appeal held that Vadoo was not an employer on the basis that its workers supply their own equipment, such as vehicles, motorcycles, and bicycles, to provide courier services. 5 years later, the High Court distinguished the foregoing decision in Hollis and Vadoo Pty Ltd in 2001. In this case, Vadoo was held to be an employer of a bicycle courier and accountable for the courier's negligence committed in the course of employment. The majority said that in the present case, guidance for the outcome is provided by various matters which are expressive of the fundamental concerns underlying the doctrine of vicarious liability. It shows that the decision was drawn in part because of the law concerned. Damages that can be sought by virtue of vicarious liability in the law of tort could have been greatly constricted had the court decided on the characterization of Vadoo as a non-employer. Nevertheless, the court noted that the decision was inferred by reference to the multi-factor test, noting that the equipment provided in this instance was an inexpensive bicycle, not a vehicle or motorcycle. The High Court decision in Hollis and Vadoo Pty Ltd brought to the fore another factor that could be considered significant for characterizing a relationship in later cases. In this case, the High Court endorsed the distinction between a contractor carrying out work as a principal and an employee carrying out work as a representative of his employer standing in his place. The court said that a contractor doesn't represent or identify with the alleged employer, and that the distinction between an employee and a contractor was fundamentally in the difference between a person who serves his employer in the employer's business and a person who carries on a trade or business of his own. Whether a worker carries out work as a principal or a representative of the principal may be considered in the context of to whom goodwill is accrued. While the High Court in Hollis and Vadoo Pty Ltd appear to take the matter in a binary sense, the question of whose business a worker represents or identifies with may not be answered in a clear dichotomy. This was illustrated in Dental Corporations Pty Ltd and Moffat, which concerned a doctor and the medical center to which the doctor belonged. The court found that the doctor was a contractor, but by virtue of goodwill that he earned for the medical center. In its decision to characterize him as a contractor, the court departed from the binary approach to goodwill and said that two sets of distinct goodwill simultaneously existed in this case: goodwill for each doctor in the medical center and goodwill for the medical center itself. The case illustrated the considerations of who is conducting what business must not supplant the central inquiry of whether a relationship is one of employment or contractor. The last point to the discussion of the multi-factor test is taxation arrangement. The court have considered how one manages personal tax affairs, such as whether a worker files income tax returns as a sole trader or an employee, or has an Australian business number, ABN, or whether the worker is registered for goods and services tax, GST, and issues GST invoices. However, those considerations have not been a determining factor, but a checkpoint to reinforce the conclusion reached. It's important to note that tax consequences may change subsequent to the judicial characterization of worker status. We are now moving on to the new judicial test focusing on contractual terms, initiated by the two decisions of the High Court in 2022. They are the personnel case. The precise citation is Construction, Forestry, Maritime, Mining and Energy Union and Personnel Contracting Pty Ltd 2022 HCA 1, and the JAMSEC case ZG Operations Australia Pty Ltd and Martin JAMSEC 2022 HCA 2. In the personnel case, the individual concerned was a 22-year-old UK backpacker, Mr. Daniel Robert McCourt, working on construction sites under the direct supervision of the builder, Hanson Pty Ltd. Hanson had labour hire arrangement with the appellant Construct that hired McCourt as a labourer. No agreement was written between McCourt and Hanson. The fact that McCourt provided unskilled labour and had limited work experience in running his own business were not disputed in this case. The second case didn't involve a labour hire firm. JAMSEC dealt with truck drivers who initially engaged with the business as employees. When the business restructured to change the workers from employees to contractors, each truck driver and spouse formed a partnership to create a tax advantage through split income. Each partnership entered into a contract with the business and invoiced it for services performed. The only significant change to each truck driver was the purchase of a truck. Little changed in terms of the actual work practices. The proceedings were brought forward by a truck driver seeking employee entitlement primarily under industrial relations law. In the personnel case, both the primary judge and the full federal court held that McCourt was a contractor and didn't operate his own business. But the reasoning was markedly different between the primary judge and the full federal court, especially in regard to control. The primary judge considered that Construct had no control over the manner in which McCourt performed work, and that he was neither integrated into the business of Construct nor represented himself as an employee of Construct. On the other hand, the full court identified control in a trilateral relationship and departed from the use of control as a significant factor. The court said that control may not be particularly helpful in the characterization of multilateral arrangement. The court recognized tensions in applying various factors under the multi-factor test in this case, but finally concluded that McCourt was a contractor. The decision was not because the relevant factors strongly pointed to his being a contractor. Rather, no clear error was found in an earlier decision involving two same parties, Personnel Contracting Pty Ltd and Construction, Forestry, Mining and Energy Union. In that earlier case, the Supreme Court of Western Australia dealt with materially identical facts and circumstances and concluded that the labour hirer in that case was a contractor. When the matter was appealed to the High Court, the decision was overturned and the relationship between McCourt and Construct was characterized as one of employment. The High Court said that the multi-factor test is not a checklist to count ticks and crosses to determine a balance. The justices then reiterated that the common law was concerned with a legal relationship, saying there is nothing artificial about limiting the consideration of legal relations to legal concepts such as rights and duties. The High Court endorsed a passage from the decision in Narrett, where Lord Brendan of Oakbrook said, "Where there is a written contract between the parties whose relationship is an issue, a court is confined in determining the nature of the relationship to a consideration of the terms, express or implied, of that contract in the light of the circumstances surrounding the making of it, and it is not entitled to consider also the manner in which parties subsequently acted in pursuance of such contract." In the back-to-back JMC case, initially the primary judge characterized the workers as contractors. That was based on the provision and maintenance of trucks of substantial value. This decision was overturned by the full federal court. the court said that trucks were not as significant as other relevant facts and circumstances. In fact, the High Court agreed with the decision of the primary judge. The High Court examined the rights and duties created by written agreement, which comprehensively regulated the relationship between each truck driver and the business. The High Court pointed out two errors made by the full federal court showing how the contract-based test applies in lieu of the multi-factor test. The first error was the significant attention devoted by the court, and indeed the primary judge, to the manner in which the parties actually conducted themselves over the decades of their relationship. Earlier, the full federal court considered what the workers were tentatively required or at least expected to do, such as displaying the hiring company's logo and wearing the company branded clothing, and the expectations that the workers, not the delegates, would perform tasks 9 hours a day, 5 days a week for the company, and that they generated no goodwill of their own. The High Court, however, said that such circumstances didn't alter the contractual rights and duties that govern the relationship. The second error was the consideration of the disparity in bargaining power between the parties affected by the contract pursuant to which the partnerships were engaged. On the basis that work practices were substantially unchanged by entering the contract for service, with the proviso that drivers must supply their own trucks, the full court took an expansive approach to determine the relationship based on the substance and reality, such as the fact that the nature of the work remained the same as when the workers were employees. The High Court, however, said that this expansive approach involves an unjustifiable departure from orthodox contractual analysis. From the two High Court cases, we can extract a concept that we can take home. That is, whether parties have comprehensively committed the terms of their relation to a written contract, the validity of which is not in dispute, the characterization of their relationship as one of employment or otherwise proceeds by reference to the rights and obligations of the parties under the contract. The court said that this contract-focused approach was never superseded by the multi-factor test. In other words, courts have always looked at the terms of a written contract to analyze a contractual relationship. Putting conservatively, we can say that under the multi-factor test, actual work practices were sought only for common law questions to the rights and duties of the parties. The exception to the contract-based approach arises when the parties have not comprehensively committed the terms of their relation to a written contract. In this case, substance beyond the contractual terms may be invited. Examples include a situation where the contract is partly in writing and partly oral, or where subsequent agreement or conduct effects a variation or waiver to the terms of the original contract. The contract-focused approach may also be departed when the efficacy of a contract is challenged as a sham or pursuant to equitable doctrines such as those relating to unconscionable conduct under the general law or statute. If so, a relevant legal issue surrounding the efficacy of a contract must be addressed first before characterizing a worker in a hire relationship. We can say that the new approach based on contractual rights and duties of the parties gives more judicial certainty in characterizing a worker in a hire relationship, but it's likely that we need more cases to settle this new test. For example, a subjective intention when entering a contract and the inquiry into whose goodwill inured, which were the factors considered under the multi-factor test, may need to be retested. Also, the new approach may characterize the worker as a contractor if the work is arranged through a partnership, trust, or company. This will be contrary to the past decision involving Roy Morgan Research, where some interviewers hired under the name of a company were held to be employees. The court said in this case that incorporation is not a silver bullet that automatically renders a worker as a contractor. This may change as a result of the new test. There are also important policy considerations. First, we need to consider whether the evolving meaning of employee is appropriate for the spirit of the law in question, because at the moment the same meaning given in common law is used in various statutory contexts. Earlier I mentioned the extended meaning of employee for superannuation guarantee purposes. This extended meaning would also need to be clarified in light of the new test for characterizing workers. Another consideration concerns the fundamental feature that laws must be just and fair. While the disparity of bargaining power at the time of entering a contract is irrelevant for characterizing a worker and hire relationship under the contract approach, challenging the efficacy of a commercial arrangement as a sham or under equitable doctrines is not an easy task. The doctrine of unconscionable conduct and equity, for example, requires conduct to be not merely unfair, but also so harsh or oppressive that it goes against good conscience, such as serious misconduct. The onus is on the stronger party to prove that the transaction is fair, just, and reasonable. To prevent workers from entering a contract from undue influence and to promote fair bargaining, legislative remedies can be provided for the identification of a real and substantial bargaining power imbalance. This can be done in areas that create contractual terms or even set aside a contract entered into in an unfair manner. With a note that we have more work ahead of us, I'll end my presentation here. Thank you for your valuable time to listen to my presentation. Thank you.